This is the third part of the anatomy of a lawsuit. So after the paperwork is filed in part one, and after all the discovery is completed, and usually somewhere after that there is a pretrial conference and a trial date scheduled, you eventually come to the point of trial. Now the reality is probably more than 90% of filed civil lawsuits never actually get to a trial. And there are a lot of reasons for that. But in my experience, the primary reasons are with competent lawyers on both sides. After you've done discovery, pretty much the lawyers can make an accurate prediction about where the case is going to end up, and we either settle the case or we do some kind of other resolution of the disputes that I'll talk about in another video, and we never get to trial. But if we go to trial, that trial is either going to be in front of a judge, or if somebody has asked for a jury trial, it's going to be in front of a jury of 6 people. Now in Maryland, for civil cases, we have 6-person juries. That's different than for criminal cases where we have the historically true jury of 12 people. In that trial, the plaintiff goes first, presents their evidence. The witnesses are subject to cross-examination. Sometimes transcripts, the written version or the video version of depositions are used. And at the end, the jury decides the case. Basically what juries do, and the reason we have trials, is to decide contested questions of fact. Let me give you an example. In an automobile accident, we have one driver that says, "I had the green light." The other driver says, "No, I had the green light." That is a contested question of fact, and that's the kind of thing that gets decided in a trial. Now, if we get to trial and it turns out that we don't have any contested questions of fact, then very simply we don't have a trial, because trials are to decide contested questions of fact. The way that situation is handled, where we don't have any serious contested questions of fact, is by motions for summary judgment, which get ruled upon by judges. So, once the trial is concluded, the judge or the jury renders their decision, and the judge then enters up what's called a judgment by directing the clerk to make a note on what's called the docket of either what the jury's decision was or what the judge's decision was. And that concludes this 3-part series on the anatomy of a civil trial.